Alex here with a legal nuts and bolts video on motions to strike. I think that I've gotten questions on motions to strike for years, and I always sidestep it. I don't want to do a video on something so. I mean, it's getting into the weeds of litigation. I think a lot of people learn about the motion to strike when they're representing themselves and their opponent's lawyer files it, and they're like, oh, that's cool. I want to do that someday. That's really what I think. I really think that's what it is. It just sounds cool to get stuff stricken. I can't imagine. To me, it's overused by lawyers. They use it too much. It triggers more motion practice, more briefing, and a lot of the problems I think can be solved without using the motion to strike. So all I'm going to say in this video is you need to do your research on whether it's appropriate to file a motion to strike. In my honest opinion, there are only a few rare situations where it's absolutely needed. Off the top of my head, sometimes somebody will strike an answer as a case terminating sanction for some kind of abusive litigation practice, maybe not complying with discovery. They'll strike an answer so that they can get a default judgment, which I'm not even sure they need that. They can probably just file a regular old motion for sanctions or something and ask for the same exact thing and get the same exact ruling from the court. Peremptory challenge of judge, that's for sure the only thing you can do. Somebody files a peremptory challenge of judge and it's not proper, the only thing you can really do with that is a motion to strike. That's a legitimate reason to use a motion to strike. And I can't really think of any. Oh, I guess some people, I guess they want to control what's in the docket and get stuff taken out of it. To me, that's like borderline possessive of your docket. Like, you're just going to make a bigger mess. More things are going to get filed to deal with a thing you don't want filed. Like, I don't know. I mean, I do know that that's why some lawyers like to do that, or so they say, and it just gets even messier, especially with a high conflict party, because the other party's going to go, ooh, now I can file an opposition, and then if you rule against me, I can appeal. And okay, you've created more work for yourself, which for an attorney means more attorney fees, I suppose. Um, Another common pitfall is lawyers will file a motion to strike a motion. I don't even know what to say about it when I see that, because now you have a motion that still hasn't been responded to. You file, there's a motion that you don't like for some reason, something's wrong with it, and you've decided to strike that with your motion. Okay, well, you still have to file an opposition to it, right? You still have to file an opposition to the unless you want to risk seeing what the judge will do. If you want to just not oppose it and just let it sit there and cross your fingers and hope the judge doesn't say, oh, you failed to respond to that, so I'm going to deem it meritorious. Just take all the stuff that you were putting in the motion to strike in an opposition instead. I don't know, guys. This is like one of the most, like I said in the beginning of the video, it's in the weeds. It's so meta. Is that the word they use now? Okay, hey, if you guys have any questions on the motion to strike, feel free to post them down in the comments below. If you found out about the motion to strike because another lawyer filed it and you think it's cool and you want to file one too, please don't do it for that reason. Use it as a last resort. In my own case, I know my ex's attorney filed it a few times. I think she complained once that I filed a reply to her reply. So basically, motion, opposition, reply, and then I wanted to add some stuff in there, so I did a reply to reply, which they call a surreply, and she decided to motion to strike that, which then I got to file an opposition to. Can you guys see where this is going? The motion to strike created more litigation. The motion to strike was complaining of litigation and ended up creating more litigation. It's the weirdest thing. So yeah, going back to what I was saying, if you learned about these because other people are using them and you want to use them too, that's not a good reason to use it. In my opinion, as a non-attorney, proper person litigant, you probably don't want to emulate and copy lawyers when they do stuff that's bizarre. The motion to strike is one of those things I think is annoying. And if I was you, that would be the absolute last thing that I would do. I would try to find any other way to solve the problem that I could possibly file or possibly solve it. And then if it was like, okay, there's nothing else I can do, this is the only way to deal with this problem, then I would file a motion to strike. For example, the peremptory challenge of judge, which is legitimately only dealt with that one mechanism. And there may also be statutes that say you can do it. There may be case law that says when you can do it. If you see stuff like that, then go ahead and follow that. That's what you're supposed to do. You're supposed to do your research, and if a statute says you can do something, if a case says you can do something, then do it. But if you just see other lawyers doing it and it's something that sounds exciting or fun, that's not a reason to do it. And I know that that's why a lot of people send me these emails, because it just sounds cool to get stuff stricken. Sounds cool, but it's a lot of work and it's annoying. All right, guys, see you next time.